All right, what I want to go over today is a general overview of estate planning, what it is, some of the principles that need to be considered when one is considering estate planning or planning their own estate, and some of the basic strategies and what we can do to create a quote unquote estate plan. Do this is I want to go over first and foremost the purpose and goals of estate planning. I think a lot of people think that avoiding probate is really what we try to do, and as long as we avoid probate, we're okay. That's one of a few goals of estate planning. Probate is, for those who aren't familiar, is the court monitored process of administering an estate, and can take years and cost thousands and thousands of dollars to effectuate. So yes, that is one of the goals, to avoid probate, but there are many other compelling goals, and we'll go over what those are. We'll go over some of the options that are available to plan one's estate. Now, kind of spoiler alert, it's a comprehensive approach to estate planning, and a more methodical approach, which we recommend is the only correct way to plan the estate. But there's a lot of kind of do-it-yourself options and strategies that we hear about kind of in articles and on the news as to certain things that can be done. So I'm going to address those, kind of what the pros and cons are, and then ultimately segue that into comprehensive planning, which is really what everybody should be looking toward. Lastly, going to want to talk about estate planning and taxes. Taxes play an important role in planning. There are opportunities to reduce or eliminate tax liability. So we're going to go over that as well. So first and foremost, let's talk about the purpose and goals. What are we trying to accomplish? When you sit down with an estate planning attorney to quote unquote plan your estate, what is the end goal? Well, first of all, we want to avoid probate. And I talked a little bit earlier about probate and what that does. Yes, the end goal is a properly administered estate, but the time and cost in doing that is just immoral in many respects. Now, so we want to avoid probate, but what we also want to do is structure the distribution of our assets rather than, leave everything outright to all of our beneficiaries, which is what a will does, which is what beneficiary designations do. We want to structure those. If they're minor children, perhaps we want to delay distribution until they're a little older. And even for adults, we want to give them options if they're in the middle of a bankruptcy, lawsuit, or divorce, that they have some options in terms of structuring those assets so as to not lose them immediately. We also try to name fiduciaries. That is what we're trying to do when we plan an estate. So these are individuals who will act on your behalf and manage your affairs. Do you have two siblings that you absolutely love, but when it comes to it, you would prefer that a cousin be the one to, handle your estate affairs? Well, this is what we do, because without proper planning, certain individuals have rights to act on your behalf, and certain individuals are natural options, and so we want to make sure that your decisions and your preferences are reflected. And also, an estate plan will minimize tax liability. So death is a taxable event. There are taxable consequences to death, so we want to plan our estate so that we're minimizing any sort of tax liability. And last, this is a little bit kind of obvious, but we do want a plan to blend into the background of your current life. When you get an estate plan, we don't want you to take upon yourself the responsibility to have to check with the trustee if you want to use money to go buy groceries, or that you're filing multiple tax returns now for the rest of your life. Those things, we don't want anything to do with that. When you create an estate plan, we want it to essentially kind of disappear. While you're alive and well, we don't want you to have to worry about it or have it be an inconvenience. Let's go into how we accomplish a certain number of those goals, but not all, and kind of what their limitations are. And these are a lot of the ideas and strategies that are out there, kind of in the open market. First of all, we can absolutely do nothing. We're definitely going to go through probate. Assets are going to be distributed outright. There's no tax planning. Obviously, hiding your head in the sand is just is certainly more harm than good. Now, what a lot of people do is they rely on beneficiary designations. So if they were to say, I've got an IRA, a 401k, and a brokerage account, and what I'm going to do is I'm going to name my children as beneficiaries on all that. Certainly, yes, that will avoid probate, but if you're incapacitated, there's really no protection there, and we still have to go to court to decide who's going to be managing those assets on an ongoing situation. Also, as referenced earlier, there's no structured distribution of those assets. So if you have minor children as beneficiaries or adult children who are, like I said, in the midst of a bankruptcy lawsuit or divorce, that could be problematic. A lot of people figure that, and this is predominantly done in real estate, that if I bring on a joint owner, like one of my children, then when I die, they remain as the sole owner. And even worse, in my opinion, if there are multiple children and they just assume that that one remaining owner is going to distribute things appropriately. Anyway, among the many problems with joint ownership as an estate planning strategy, you do significantly increase your liability. I've been in situations where I'm working with clients who are, in their 70s or 80s, and their kids, whom are joint owners on the house, to have to declare bankruptcy, or they're going through a divorce. And what we've got is the elderly client's home on the chopping block. So if you have your kids on as joint owners and they get wrapped up in a lawsuit or a business deal gone bad, you could lose your house without any sort of recourse. So anyway, that is a huge limitation. Also, there's a significant tax opportunity that we give up when we pass assets through joint owners. We can create a will. Now, I don't really need to describe what a will is because it's very commonplace. We know what it is. But what a will does is it guarantees probate. So that's kind of one of the primary things we're trying to avoid, and a will simply doesn't do that. Now, if we create a living trust-based estate plan, we do accomplish all of these goals. This is the comprehensive planning, which we're going to talk about next. It avoids probate. It appoints a fiduciary to manage assets upon incapacitation. It provides for a structured distribution of assets, and it provides numerous tax opportunities. So when it comes to planning our estate, certainly we've got these top four options, but really we are only doing ourselves a disservice to think that we're accomplishing what we need to accomplish by doing them. So we really need to be looking at a living trust-based estate plan, especially if we live here in California. So let's talk about what that comprehensive approach is. So a revocable living trust is going to manage assets in times of incapacity and death, and it's going to avoid probate. So we'll talk about how a trust works, but essentially it's an entity to which we're transferring our assets, and a trustee is going to manage those assets for our benefit, of course, if we're incapacitated, and then to our beneficiaries upon death. And it completely bypasses the probate process, which is a huge advantage of creating a living trust. As part of a comprehensive plan, we also want a power of attorney. This is going to appoint individuals to act on your behalf should you be incapacitated. These individuals will be signing your tax return, talking to your retirement planning specialist, dealing with any pension issues. So that's what your power of attorney is going to do. We also want an advanced healthcare directive. Now you're preemptively able to make medical decisions and put them in the directives, pulling the plug and organ donation, blood transfusions, kind of things like that. But you're also able to appoint agents to make decisions that you don't make ahead of time. And so managing your healthcare is absolutely essential with healthcare directives. A pour over will. Now we did say a will is subject to probate, which is true. And if we have the living trust taking care of all of our assets, then we're in a very good place. If there is a problem with one of the assets or a hiccup, we have a will in place to act as a backup. And the will simply says we want any assets that are being administered outside of the trust to go into the trust. So really, you can play baseball without a backstop. And ideally, the pitcher's trying to get it to the catcher, the batter's trying to hit it, but that backstop is there in case something happens that nobody's expecting. Also in California, will is where you nominate guardians for your minor children if you were to pass while they're still minors. Lastly, as part of a comprehensive approach, we've got a series of corollary documents, which I think is beyond the scope of this video to kind of go over what those do individually. But in short, there's a group of documents that provide support and additional protection for the rest of the plan. So what we're looking at here is a textual representation of what a comprehensive estate plan roughly looks like. What I'd like to go over now is kind of how that functions graphically represented. So we're going to do an example. Brian and Camille, me and my wife, we are the creators. So we're going to create a family trust, okay? The proper legal term we use is settlor, okay? So we create a trust, which is an entity in and of itself, kind of like a corporation without any of those formalities. And it's a separate entity because it can own assets. So we actually transfer our assets into the trust. So our home, our business, our finances, everything kind of goes to the trust. So Brian and Camille don't necessarily own the house anymore, but the Eisenweiss Family Trust owns the house. Now, we appoint ourselves as the trustees of the trust, so we're the only ones that can manage the trust. So we're not giving up control when we transfer our assets into the trust. And I think most importantly, we are the beneficiaries of our trust. So when we take our house and we quitclaim deed it over into our trust, we need to understand that we are in charge of the trust and we answer to no one. And also we are the sole beneficiaries of the trust. So at the structure you're looking at now, we're really looking at what I call a pointless structure. Because while we're alive and well, this is of zero utility. This is doing nothing. What you're looking at right now is how we manage our finances without a trust. But this isn't why we create an estate plan. And to the contrary, we actually create an estate plan, like one of those goals is for it to blend into the background of our lives. And so at this point, while we're alive and well, it's really not supposed to be doing much. However, should we become well, actually, I'm getting ahead of myself. So what we do also before we jump into the real value of the trust is we appoint successor trustees. So if Camille and I are incapacitated, which I believe is where we're at here, we are unable to act as the trustees. So, if we're, dementia or Alzheimer's, we can't manage our own assets. And by the way, I grayed out our role as settlors because once you create the trust, there's really nothing that's done in that role anyway. Once it's created, it's created. So my wife and I as trustees, let's say we both have Alzheimer's, we're unable to manage our own affairs. So we have a successor trustee who steps in to handle that for us. Now we remain the beneficiary, so that successor trustee is managing our assets for our benefit. Now if this successor trustee is unable or unwilling for whatever reason, of course we have another backup. So when we are incapacitated, we have a successor trustee having access to our trust assets and administering those assets for our benefit, because again, we're still alive. We need that money. We need those resources. Nobody else gets those assets, and the trustee is doing us a huge favor, and they can be compensated. We can talk about that later, but they are managing these for our benefit. Now, if we ultimately die, then we can't be beneficiaries. So obviously, when we're deceased, we can't manage the trust. And the old adage, you can't take it with you. We are no longer able to be beneficiaries of the trust. So the successor trustee still has access to trust assets, but at this point, they are actually administering and distributing them to the beneficiaries of the trust. Now, technically, we are beneficiaries, and our children would, I guess, technically be successor beneficiaries. But the proper nomenclature is that the beneficiaries are who gets the assets after death. And for us, that is our children. Now, they're not administering these kind of for ongoing support unless we specifically say so, but the role of the trustee at this point upon our passing is more of an executor of an estate. So they are wrapping things up and making sure that our assets are distributed how we want. So this right here is a living trust. So when you hear about a living trust or a revocable living trust, This structure right here is what we're looking at. A living trust isn't enough for a proper estate plan, as we discussed, because we also need a power of attorney, healthcare directives, and those pour over wills. And we already talked essentially about how those work. Now, this is an absolute bare bones estate plan. This is at this point, this is where I'm comfortable to say that this is better than nothing. Okay. But we don't want to do this. I think if you go onto like a LegalZoom or a do-it-yourself kind of document preparation service, this is the type of package you're going to get, but it's not a complete, because we do have those other documents which are important. We call them corollary documents, but they are important. These documents include documents such as a declaration of trust, a certificate of trust, a marital property agreement, an assignment of personal property, and so forth. For example, a marital property agreement, that is going to clarify that any assets named in one spouse's name and not the other should be disregarded as certain intent, and that everything is supposed to be in the trust regardless of, you know, husband's or wife's assets. And even if there's separate property issues, we address that inside of the trust. So that marital property agreement is huge for second marriages. Declaration of trust, kind of over there on the left. That really has to do a lot with what happens when we're taking an inventory of your assets after death and find out that maybe one or two of them aren't subject to the terms of the trust, which would be an error on the client's part. But that declaration of trust fills in that gap. So this right here is going to be a comprehensive estate plan, and the answer to the question, how should I plan my estate? 99 times out of 100 for a California client, it's going to be this comprehensive estate planning package right here. Okay. So let's talk about estate planning and taxes. Okay, so there's a lot of taxes kind of floating around when it comes to estate planning. The first tax that we talk about is the estate tax. The estate tax is a tax upon one's estate upon death. This is prior to distribution. So if I die with $1 million, the estate tax is a tax on that million, and then what's left over is then distributed to my beneficiaries. So that tax is a tax on the estate. However, we don't really need to worry about it. It's at a little over 11. That 11.44, I believe, in 2020 got bumped up to 11.54, I think, but it's right there around $11.5 million of estate is excluded from this tax per individual. So a married couple essentially can exclude up to $23 million of net worth upon death. So for most of us, this is likely not an issue. There are estate tax planning strategies we can implement, but for most of us, when we hear estate tax, we don't really need to be scared, okay? Because that really just applies to this kind of married couples north of 23 million. Now, the gift tax is a tax on the giver of lifetime gifts. So if one is, let's say one is hypothetically over $23 million and they want to reduce the value of their estate in later years, they would be giving that money away. But Congress, knowing that that is a way to dodge the estate tax, taxes those gifts as well. Now, when we give money away, that's obviously while we're alive, we can give away $15,000 per giver per recipient. So my wife and I can give my oldest child $30,000 per giver per recipient. We can give our middle child $30,000. We can give our youngest child $30,000. So we can move $90,000 out of our estate, my wife and I, to our 3 children. So if we're trying to reduce the value of our estate, or if we're trying to kind of advance distributions to our children, we can do that as long as we keep it under that $15,000 per giver per recipient. So since that is quite a broad or a large amount, we say it's likely not an issue. There are gift tax planning strategies, but for most of us, it's not really an issue. Actually, before we get into inheritance tax, let me kind of go back to the gift tax real quick. If we give away more than $15,000 per giver per recipient, then that 11.44 million number up there, that gets reduced dollar for dollar. So if we've got $23 million and we try to give away $23 million on our deathbed, then we essentially lose our estate tax exclusion. So I guess what I'm getting at with the estate tax and the gift tax is we hear about these, they make it on Forbes articles and CNBC and Fox News, but we really don't need to worry about the estate and the gift tax for most of us. If we are high net worth, certainly let's chat. There are planning opportunities, but for most of us, we don't need to worry about it. Now, the inheritance tax is kind of the answer to the estate tax. The estate tax is a tax on the estate prior to distribution, and then each beneficiary pays an inheritance tax as it comes to them. Now, the inheritance tax, there is no federal inheritance tax, and there is no California state inheritance tax. So for beneficiaries here in California and for an estate here in California, there's not going to be any natural tax simply because of death. Now, there are a few states back east that do have an inheritance tax. And so let's say hypothetically, if we've got a $30 million estate and we have a beneficiary in Wisconsin, I believe Wisconsin is one of the estates with estate inheritance tax, then you've got an estate tax on the estate before it's distributed, and then another inheritance tax on the beneficiary as it comes in. But here in California, we don't have a state estate tax. Most of us are far below the federal estate tax. We don't have a state inheritance tax. So far, looking at these three taxes, we really don't have much to worry about. Now, the income tax is a tax on all accessions to wealth, but pursuant to the Internal Revenue Code, an inheritance is not counted as income. It's specifically carved out. I do come in contact with certain individuals who are concerned about an inheritance year being a huge tax year, but that is not an issue. It's false. Now, we do have taxes associated with real estate, and there's two of these. Number one, we've got property taxes that we obviously don't want reassessed. In California, we've got Prop 13, which keeps our property taxes really low, and ideally we want those low taxes carried over to our children. Also, capital gains taxes. You purchase real estate, the real estate grows in value, and we sell that real estate. That growth or that profit is considered capital gain, and we pay taxes on that. So most of my clients have purchased their properties, decades earlier, and if they leave them to their children and their children sell them, then there's a huge capital gain that we need to talk about. So first and foremost, when it comes to property taxes, parent-child transfers are not reassessable and get a step up in basis. So let's talk about the first half of that. So is individuals, if you create an estate plan and leave real estate to your children, that property cannot be reassessed. Okay. Now there is $1 million exclusion to that, but for most of us, if we're just transferring a primary residence, $1 million of non-primary residence. So if we just transfer primary residence, then we simply the property taxes are a non-issue. Now, if we're transferring it to non-children, then that is an issue. There aren't really ways around that, but there's certainly planning considerations that we can look into. Lastly, property gets a step up in basis. So when assets are in one's trust estate when they die, that cost basis or that purchase price resets. So let me illustrate that. Mom and dad purchase a property for $200,000. It's $1 million when they die. And so if they were to sell it the day before they died, they would owe capital gains taxes on $800,000 of gain. Now, when they die, that cost basis to them, which was 200,000, that actually gets reset to the date of death value, which would be $1 million. So as the kids inherit the as the kids inherit the real estate, they are claiming a $1 million cost basis. So if they were to turn around and sell it later that year, assuming no dramatic changes in the price of real estate, they would have to pay zero capital gains taxes on that property because there wouldn't be a capital gain. And in a down real estate market, they may even have a capital loss, which is a tax deduction, which would be a neat little advantage if that was present. So that is estate planning in a nutshell. If you have any questions, obviously feel free to reach out to us. Phone number and email are right there. Free consultations, and we love sharing information with people. We know it helps set people in the right direction, and if we are available to have the opportunity to help you implement that, we would love that as well. Feel free to reach out to us, and we'd love to talk. Thanks for your time.